A common mistake of young lawyers in trial is confusing an impeachment of a witness with a refresher of a witness. In an impeachment, the witness has made testimony that's contrary to a prior statement or document. The statement or document should be used to show that they are testifying in a contrary manner at trial. With refresher, the witness has stated that they lack the memory to adequately respond to the question, but they previously had the memory to respond, whether in a deposition or in a prior document, such as an email. The document is used to allow the witness to refresh their own memory so that you can ask the question again and get the proper response. Let's walk through how both of these play out in the courtroom. When a witness is asked a question and testifies contrary. So it's your testimony today, Mr. Johnson, that you did not authorize the ceasing of payments. Your first step is to confirm the contrary testimony. Then move on to impeaching with their deposition. Let the record reflect I'm showing opposing counsel a copy of Mr. Johnson's deposition testimony. Your Honor, may I approach the witness? Provide the witness with a copy of the deposition testimony. Mr. Johnson, you were deposed in this matter. You were deposed in this matter in June, and I've provided you what is a copy of your deposition. And on the last page of that deposition, that's your signature. I'd like you to turn to page 29 and read along to yourself as I read out loud your testimony. Mr. Johnson, did you authorize the stopping of payments to my client? Answer, yes, I told the CFO to stop paying local company. Thank you, Mr. Johnson. I'll take that document back from you. At this point with an impeachment, you move on. You've made your point and you've clearly identified that Mr. Johnson previously testified he authorized the ceasing of payments. On a refresher, on the other hand, your witness lacks the memory. So, Mr. Johnson, you don't recall whether or not you authorized the company to stop making payments. After you've confirmed their lack of memory, confirm that there's a document that would refresh their memory and then allow them to refresh the memory themselves. Do you recall being deposed in this case? Do you remember you and I's conversation about the payments? Would seeing a copy of that prior conversation help refresh your recollection? I am showing opposing counsel a copy of Mr. Johnson's deposition. Your Honor, may I approach the witness? Mr. Johnson, I'm providing you with a copy of your prior deposition. If you would, please turn to page 29 and refresh your recollection by reading along silently to yourself and let me know when your memory is sufficiently refreshed. This is one of the key differences. In an impeachment, the attorney reads the document out loud to make the point to the court. With a refresher, the attorney needs to allow the witness to refresh their memory themselves, then re-ask the question. After you've sufficiently read your deposition, let me know when your memory is refreshed. Thank you. I'll take that from you. So, Mr. Johnson, I'll ask you again. Did you authorize your company to stop making payments to my client? At this point, the testimony should be consistent with the prior document. If it's not, start the process all over again as an impeachment.